Attorney General Faris Al-Rawi is hoping that public persuasion can get the opposition to support the bail amendment bill. The bail amendment bill was shot down in Parliament last Friday after the opposition abstained from voting. The bill requires a 3/5 majority. Karen Philip has more in this report.
The bail amendment bill is designed to prevent persons charged with possession of arms and ammunition from getting bail for 120 days. At a media conference on Tuesday, the Attorney General recalled statistics for the years 2009 to 2019, where 6,387 people were charged for illegal possession of a firearm, while a total of 17,271 firearm-related offenses were committed in Trinidad and Tobago.
Trinidad and Tobago cannot afford to go to bed on this issue. Why? When we saw the collapse of the bail amendment law, when the UNC refused to support the law, when Mrs. Prasad Bisesa refused to support the law, it was the public outcry that allowed that law to come back to Parliament.
On Monday, the opposition leader said she felt the bill was too draconian, had the potential for abuse by the police, and was a violation of citizens' rights without the appropriate checks and balances. The opposition's proposal is for refusal of bail to a third-time offender rather than bail being refused to a first-time offender. However, the Attorney General argued that between 2011 to 2015, the People's Partnership government amended the Bail Act to a similar version of the bill, which they now refuse to support.
But you cannot understand their logic or lack of logic, because in the period 2011 to 2015, you could not get bail for 120 days minimum if you had a firearm matter. It's not the case since 2016, 17, 18, 19, and 20 under this government.
The Attorney General made the point that under Section 5, subsection 7A of the Bail Amendment Bill, a person can, in exceptional circumstances, make an application to a court for bail. Karen Philip, TTT News.
Attorney General Faris Al-Rawi says Trinidad and Tobago's courts are not closed. Contrary to claims which say that courts have not been on operation, the Attorney General said thousands of matters have been heard. As he responded to a question in the Senate today, Mr. Al-Rawi said over 5,832 matters have been heard in court during the period March 16th to May 13th. He said 1,450 matters were heard directly at the prisons as a result of virtual hearings. During the sitting, the AG was asked to advise on the time frame for the reopening of the courts by Senator Wade Mark. Senator Mark's question came in light of a request to the Chief Justice by the Assembly of Southern Lawyers to have courts reopened. The Attorney General said he received the same correspondence, but added that Senator Mark's version was grossly incorrect.
I reject Senator Mark's attempt to misconstrue the letter written by the Assembly of Southern Lawyers, because it is in fact not correct. The courts are open. They could not be open and have 5,832 matters passing through them. This is just a gross misrepresentation of the position, and I want to reject out of hand the attempt to make false allegations, not only of the Assembly of Southern Lawyers, but that the courts are closed. That is just not true.